The broadcast is now starting. All attendees are in listen-only mode.
Thank you everyone for joining us for another Learning Lunch, hosted by ForMed Approved, formerly EMR Approved, and ForMedTraining.com. My name is Brian Johnson. I'm the Senior Director of Online Education with ForMed Training, and I'll be your moderator today. Today's Learning Lunch will cover meeting the HIPAA training and business associate requirement. We are joined today by Mike Simmel, a professional security consultant and top expert in HIPAA. Mike is also the lead contributor to our weekly ForMed security column at ForMedApproved.com. Our presenter is uniquely qualified to address today's topic, and we are honored to have this opportunity to share his expertise with you. If you have questions during this session, please enter them into the chat area during the presentation. In the second half of our presentation, we will address as many questions as time allows. If we do run out of time, answers to all submitted questions will be posted to Mike's column and sent via email link later in the week. Also, as we are often asked this question during the session, please note that all registered attendees of today's session will receive an email with links to both the recorded and PDF versions of the event. All right, Mike, let's start. So what are the biggest changes related to business associates in the HIPAA Omnibus Final Rule?
It's a good question, Brian. They're pretty big, and they go back to the High-Tech Act of 2009 that said that business associates will have to comply with HIPAA the same as covered entities and also be directly responsible for data breaches and non-compliance. Directly responsible means that if the business associate causes a data breach, unlike in the past, they will be able to be fined and penalized for that data breach by the Office of Civil Rights, which is a department in the U.S. Department of Health and Human Services. The other thing is that business associates are now responsible for ensuring the compliance of their subcontractors. So a subcontractor would be any entity or person that a business associate works with that's not part of their workforce. So in the case of IT companies, very often they're reselling cloud services or online backup services. So the covered entity would contract with the IT company. The IT company would be reselling a service and would have to work with their subcontractors and perhaps their subcontractors' subcontractors to make sure that everyone's compliant that has any possibility of touching or maintaining data. And the third big change is that in the past, paper storage companies and data centers that did not actually access the protected health information. So in the case of paper storage, they would pick up boxes of medical records and store them in warehouses. Data centers very often housed servers and data, but didn't even have the codes to be able to access that, the encryption keys and the even the physical keys to unlock data cages. And now that they are part of this new rule, the rule says that if they maintain data, that's the new buzzword, they're now business associates. So even if they don't look at it, if the data's in their facility, they have to comply as business associates.
Now that business associates will become directly liable for compliance and data breaches, does this reduce the responsibility of a covered entity?
No, actually the covered entities are still responsible and perhaps more responsible than ever. So in the past, the covered entities that brought on the business associates were responsible for any data breach caused by the business associate. If a business associate lost a laptop or in some other way breached the data, they would report it to the covered entity, and the federal government could only reach out to the covered entity and penalize them. They had no way to reach out to the business associate who was under a contract to the covered entity. Now, the contracts will still be in place, the business associate agreements, but if there's a data breach caused by a business associate, the federal government can come down both on the business associate and the covered entity. And the reason the covered entity becomes responsible for this is they are the entity that invited the business associate into the process that allowed the business associate to have access to the patient data that's been entrusted to the covered entity. So now covered entities are still responsible, and with this new rule about the subcontractors and adding organizations like data centers and paper storage facilities, they're even more responsible in the sense that they have more people down the line that may breach the data if they have any data breaches.
Do current business associates have to comply with HIPAA, or does the rule only apply to new business associates?
All business associates have to comply by September without any exceptions. So current business associates, as in organizations that have had contracts perhaps going back to 2005 when the rules kicked in, still have to comply, and the new business associates will also have to comply. There's been some confusion, which we'll get to in a slide shortly, that talks about the contracts themselves and some deadlines that are different between current business associates and new ones. But every business associate has to comply by September without any exceptions.
Some sources suggest that current business associates have until September 2014 to comply. Is this true?
No, Brian, this is where the confusion is. So if you read the rules, they put a September 2014 date in, and that's the date that current business associate agreements that are already in place can be replaced by. So the covered entity that currently has business associates and has agreements with them has until September 2014 to update the agreements. However, the business associates must comply by this September 2013, and face penalties after that if they aren't in compliance with HIPAA.
If business associates don't have to implement compliance programs until September, does that mean they don't have responsibility for protecting patient data until then?
No, that's some more confusion because of these dates and what is going to be enforced in September. The business associates have access to patient data, and they still have to follow the guidelines of their business associate agreements with the covered entities. So a covered entity providing access to a business associate to the patient data has the responsibility to make sure that that data is protected, and a business associate, even without a contract, has to comply with the basic terms of the contract, which says that they can't breach the data and they have to protect it so that it doesn't get released. Right now, if there's a data breach, the business associate still reports it back to the covered entity and will not face direct penalties. That's what they have until September to comply with. However, right now, they still have to protect the data because they have a responsibility to the covered entity and the covered entity's patients to protect the data.
Can an organization continue to use their old business associate agreements for new business associates?
No. The HIPAA Act said that business associates have to comply, and that wasn't created until 2009. Originally, business associates had to comply back in 2005 when the rules kicked in, and the new guidance was just published in January, I believe January 25th of 2013, and it's out on a Health and Human Services website. And that guidance refers to the HIPAA Act and the new rules about subcontractors. So you really have to replace the old business associate agreements with new business associate agreements. So right now, if you're signing up new business associates, you should give them a new agreement, and you do have September 2014 to replace your current business associate agreements with those that comply with the HIPAA Act and the HIPAA Omnibus Final Rule.
How can an organization possibly track the compliance of all these different business associates and their subcontractors?
Well, it's a tough question because in the past, I think a lot of organizations were a little bit loose with maintaining good lists of who their business associates are. There's guidance out on the Health and Human Services websites about who business associates are or could be, and they're companies that come in contact with protected health information. So when we talk about protected health information, it doesn't have to be electronic like a data file. It could be verbal and it could be written. So when we're talking about written documents, obviously paper charts and paper records, companies that pick up and store those files are business associates. Companies that come to your office and shred those files are business associates. There are some organizations that provide different kinds of financial services, and they may be touching patient records that are in paper or electronic format. Lawyers that represent the healthcare organization. So if an organization is sued, say, for malpractice, and they need to provide their attorney with information about patient care so that the attorney can defend them, the attorney now is a business associate, and that's because the patient is not providing the information. It is the covered entity providing the information to an outside source or resource. Accountants that review financial records and will come in and audit a medical practice or a hospital or an insurance company, where they're going to look at medical records as they track financial data through the systems for financial auditing purposes, are also business associates because they're coming in contact with the patient information and they're not part of the workforce, part of the covered entity's workforce. When we get to verbal information, we're talking about organizations like answering services. So an answering service that's going to pick up the phone after hours for a medical practice is going to talk to a patient, find out perhaps what their name is, what their complaint is, and then forward that on to a physician or whoever's on call. So now you've got verbal information that's being stored, and these are all different examples of business associates. So the first thing that you have to do is review who's providing services, and if they come in contact with patient data in any form, they're a business associate. The next thing that you have to do is work with those business associates, provide them with agreements, and explain to them what's expected in terms of HIPAA compliance that they have to do, require that they provide you with a list of all of their subcontractors that come in contact with the data. So going back to an IT company, if the IT company is selling, for instance, online backup services, that you want to know who the online backup provider is and also the resources, for instance, a data center that the online backup company is using, because that's where your data may be ending up every night or every hour, whatever the frequency of the backups are. So these are things that you need to track, and there's no specific format for doing this. The federal government doesn't have a form to fill out or any way, specific way to track this, but the way to do it is that you need to work with your business associates to get evidence of their compliance. So you can require that they provide you with copies of training certificates, for instance, for their employees. You can require that they provide you with their policies and their procedures that they've implemented to comply with HIPAA in relation to the data that you're allowing them to access. And you can require them to provide you with copies of signed agreements. The term could be sub-BAs, BAA. So a business associate agreement would be between the covered entity and the business associate that they do business with. And then as you work down the line, there would be sub-business associate agreements between the business associate and their subcontractors and the subcontractors' subcontractors and so forth. So what you really want to do is make sure that you've got evidence because it's best to think like an auditor. If there was a data breach, or if there was an audit of your organization and they say, we need to see proof that you are in compliance and that your business associates are in compliance, you're going to be scrambling under a lot of pressure to provide the evidence to an auditor that you're compliant. It's better to do that up front and build the files and make sure that everybody's compliant before you run into a problem or find out that someone said that they were compliant and then never did anything about it.
What if business associates refuse to comply?
Well, there's a simple term for that. And I think, again, when you look at it from the standpoint of an auditor or from the HIPAA enforcement folks at the Office for Civil Rights, if a business associate meets the qualifications, which means that they have access to patient data and they're not part of your workforce, and they refuse to comply with HIPAA, any information that they would see, any patient data they would have access to, again, in any form, paper, written or verbal or electronic, would be a data breach. So it's no different that, for instance, if a shredding company said that they won't sign a business associate agreement, the person that comes in and takes that locked wastebasket out to the parking lot to dump it into the shredding truck, if there's no business associate agreement in place and they open that wastebasket and they touch a patient record, that technically is a data breach. And you could have thousands of pages in a wastebasket, so you could have thousands of records that are breached simply because your vendor refuses to comply, and you have no choice at this point but to terminate your relationship and find other suppliers. One of the questions I get asked, and I'm not an attorney, but the question comes up, well, what if we have a contract with a provider and they refuse to comply? In most contracts, there's what's known as a force majeure clause, and typically it talks about disasters and strikes and acts of God. But most of the force majeure clauses that I've seen also include a reference to change in government regulations. So the HIPAA Act in 2009 said business associates have to comply. They weren't required to comply until the rules were published in January, and then of course we have till September before enforcement starts. But the rules did change. So if you've got a contract with someone and they have access to patient data and they claim that they're not a business associate, or for instance they're selling you a service, and if you go down the line through the subcontractors, one of their key subcontractors says that they're not a business associate and they won't sign an agreement, then you have no choice but to terminate that relationship and find another supplier. The question becomes, how long can you wait until the September deadline if you have to find other suppliers?
Well, how can an organization get all of this done before September?
It's difficult, and part of the answer has to do with how far are you along with your HIPAA compliance program. So if you go back for covered entities, the HIPAA privacy rule went into effect in 2003, 10 years ago, almost to the day. The HIPAA security rule went into effect in April of 2005, so 8 years ago. One of the things that I've seen in my travels and talking with a lot of medical practices is that they did a lot of work to comply with the privacy rule and did not do much to comply with the HIPAA security rule, which is the one that has a lot more detail and is focused on electronic protected health information. So my answer to people is, first of all, you need to start now. If we look at the calendar, we're in April, and it seems like from April to September, there's a long time. The problem becomes that in the summertime, it's pretty difficult in many organizations to get a lot done because of vacations and other distractions. And if you wait until July, August, or September, there's only 3 weeks in September from the beginning of the month until the compliance date. And it's going to be very difficult unless you start now and start getting your ducks lined up and going through checklists to make sure that you're hitting all the specific requirements of the HIPAA omnibus rule. And if you didn't comply originally with either the privacy rule or the security rule, you've got to go back to square one and start from there. The HIPAA omnibus rule is an update to the other ones, and if you didn't comply from the beginning, you've got to go back and start there and then work your way up to the point where you're complying with the HIPAA omnibus final rule.
Is there any chance that the deadline might be extended by HHS?
No, HHS has said they're not going to extend the deadline for several reasons. One of them is that the information about business associates having to become compliant was published back in 2009, and there was an interim rule published in the later part of 2009. So not everything that was in the omnibus final rule was known at that point, but the basic information was out there that business associates will have to comply. So the Office for Civil Rights is saying that essentially people have had over 3 years now of warning, and they should have been prepared for this because all the information has been out on federal websites in terms of what compliance requirements there were for covered entities, and by saying that a business associate has to comply just as if they were a covered entity meant that people could have gone out there and seen what their requirements were. The other thing that OCR said was that because the business associate agreement should have been in place, the business associates should have been following a lot of these guidelines, even though they didn't necessarily have to have all the components of a HIPAA compliance program, and they weren't directly liable, that since they were business associates, and the assumption is that they knew they were business associates and had contracts in place, there should not be a lot of work to do to go the extra steps to become compliant by September. The last thing is that the rule was announced in January, and it went into effect March 26th, and then they've given 180 days of a grace period for these business associates to comply. So they're saying they warned people years ago that you'd have to comply, that there were agreements that should have been in place that required that the data be protected anyway, and after the compliance date was announced, they've given 6 months for people to implement the programs. So those are the 3 reasons that they've said they're not going to extend the deadline.
Where should a business associate begin to start its compliance program?
I think the most basic thing is where any sort of program or any sort of process begins is with training. So when you look at an organization, and it doesn't matter whether you're a covered entity or a business associate, there are people at the management level that deal with strategic decisions, and then as you work your way down the organizational chart, you have people at lower levels that deal with tactical decisions. So as you're looking at the org chart, you have to kind of draw the line where the difference is between strategic and tactical. And anybody that's at a strategic level that has to be responsible for compliance. And by the way, every HIPAA covered entity and now business associate has to assign security responsibility. That's a HIPAA requirement. So you have to appoint a security officer, and that security officer is responsible for your organization's compliance. Now, it doesn't mean that they have to do all the work. The work could be delegated within the organization or outsourced to a HIPAA consulting firm, but that person inside the organization has to be responsible for it. That's the obvious person who should be taking HIPAA certification training so that they truly understand HIPAA. They know the types of rules that are in the process. They know the details within those rules. They understand what they have to do, what the business associates have to do. They understand what their internal IT department would have to do, or an outsourced IT provider would have to do. Again, they don't need to know how to do all the different things, but if they're responsible for the compliance, they have to make sure that those things are being done. So HIPAA certification is the best way to do that. When you get to the workforce, the lower level folks, they don't need to know all the background of HIPAA and all the specifics of the rules. They need to know some specific things that they need to do in the course of their work to prevent any data breaches and make sure that the proper reporting is done, the proper documentation is done, so that no one has a compliance problem. So the workforce training is faster. It's designed for the end users in the organization as opposed to the managers.
Tell us something just as far as the documentation goes. What do you recommend for that?
Well, again, you have to think like an auditor. So if there was a data breach and there was an investigation, or if there's an audit, and the auditor shows up and says, have you trained everyone? And you say yes, they're going to say, show us evidence of that training. So you're going to need to show a couple of things. The first thing you need to show is what it is that people are being trained on. You need to show the content of your training. But the second thing that they're going to ask for is prove that your workforce has been trained. So the way to do that is through sign-in sheets, or the easiest way using today's technology is to have an online learning system that would have both the training materials and also track who was trained. So the challenge for an organization is that you've got a current workforce, and then as time goes by, you're going to be adding people to your workforce. It surprises me when I talk to medical practices and I ask about their HIPAA training, and they tell me that they do annual training similar to OSHA training and other types of training that's required for healthcare safety, and they wait until the cycle comes around to do the training. So a new employee may get trained up to a year after they've joined the organization. The specific requirement in HIPAA is that employees be trained on HIPAA before they're given access to your patient data, which means that it needs to be part of your HR onboarding process to get people trained and to document that training before the IT department is notified or the administrative department is notified, whoever provides that person with access to patient data. And remember that we're not just talking about electronic systems. They could be somebody in a role that, again, deals with paper or answers the phone at a healthcare facility and may not even have access to an online system, but is going to be hearing or seeing protected information. And just for the record, protected information is any combination of a patient's name and any treatment or diagnostic information. So it could be someone calling in or asking to have a prescription refilled, so their name and a medication. It could be something that they call into an answering service and say, please have a doctor call me because I'm not feeling well, I've got an upset stomach and my name is such and such and here's my phone number. Just that information alone is protected. And while we're talking about it, be very careful, and you have to educate your people not to do things like using Gmail accounts and other consumer-based email systems to send patient data, and also not to use text messaging through the online carriers like AT&T and Verizon and T-Mobile, because that's not secure. So nothing that has the combination of a name and any diagnostic and treatment information should be in there. These are the types of things that you want to be able to show your training your end users on, because those are the things that they have to deal with on a daily basis. So the documentation could be as simple, if you're a very small office, of a sign-in sheet, and then a document in each employee's record, a new employee's record, that they've received training before they were given access. In a larger organization, and larger, I would say probably any more than 10 or 15 employees, an electronic system is a much easier way to manage this.
Do all of our staff members have to be certified in HIPAA?
No. As I mentioned before, I think people that are at the strategic level making decisions and being responsible for compliance should be certified in HIPAA. Workforce members should have a certificate or some record that they were trained with a workforce training, but it's not necessary for each of them to get a full HIPAA certification, because that's probably not appropriate for their job, and it would just take longer and not be of benefit to the organization to have everyone running around HIPAA certified when many of the roles are at a level where they just need to know what behaviors they need to be careful of.
Well, and while we're on the topic, maybe you could say a word about awareness programs and what you think is advisable for that.
Okay, so there's a big difference between training and awareness. Training is literally training. It's sitting down and going through a course, whether it's a lunch and learn, perhaps like we're doing today, if an office goes out and buys pizzas and does a PowerPoint training session for their employees on the do's and don'ts that relate to HIPAA, that's training. And I think we all understand what training is. Awareness is different. Awareness is a series of reminders, ongoing reminders, and they can be in different formats. And we don't really think of these things in some cases, but they're different systems. I'm looking at a computer right now. When I turn on my computer, the operating system has the ability to send a message, and network administrators that may be on the call know how to do this, to put a welcome message on, and in some cases they're putting messages on that remind people that the information that's contained in the system is protected and it needs to be secure, and that the access to the system is a privilege. So that's an example of awareness. There could be simply posters, and I've seen magnets, refrigerator-type magnets on file cabinets in medical offices that say, keep this cabinet locked, or no unauthorized personnel. You can have cartoons, for instance, and recently I was at the U.S. Capitol, and in the House of Representatives dining room where the employees eat, there was digital signage, television like many large healthcare organizations have, flashing signs and messages, and one of them had a dinosaur breathing fire holding a USB stick, and the message was, don't insert any USB thumb drives in your computer that haven't been checked and approved for security. And it's very easy to put a virus or put malware on a USB stick, and if you dropped it in somebody's hallway, I work with IT security people, they say it's likely to be just a matter of minutes before somebody picks that up and takes it to their office and plugs it in, and they could infect the network and provide a backdoor unauthorized access into the network. So the House of Representatives just had this cartoon flashing that was warning about using unauthorized USB sticks. Putting up notes about passwords. When I was the CIO in a hospital, we had a graphic image of lips with a zipper across them, and we put that in the cafeteria with a message saying, your password is your password, don't share it with anyone. So those are examples of awareness documents or programs that are different than training. we weren't training anybody specifically by putting those signs up. We were just reminding them about IT security, and it ties back to the specific HIPAA regulation that you have to have an awareness program. One of the problems with awareness programs, and use that example of the visual graphic on the House of Representatives television, how do you prove that it was there? If you're ever audited and someone says, do you have an awareness program, and you say you do, they say, prove it. Well, somebody that's responsible for compliance could use very simple tools to document that the awareness program's in place. You could use the camera on a cell phone and stand in front of a digital sign or in front of a poster on a wall and take a picture of that and email it to yourself, add some information saying this is our awareness message for April of 2013, and we printed up X number of these posters, we deployed them in all these areas of our hospital or of our medical practice, and we took them down at the end of the month. So that's a way to document that the event took place, even though there's no way to specifically record it in any single system. So, you know, we don't think of our cell phones as cameras unless we're out with friends or maybe at a family event, but a cell phone camera with the ability to email is a very easy way to prove compliance with an awareness program.
All right, we have a lot of questions today. If you'll bear with us for just a moment while we bring them up, we will have questions for Mike. This will take just a moment. All right. All right. Let's have a look here. First of all, several people have asked whether they can get the slides and whether there's a recorded version available. And again, after the session is concluded, we will send out links for a recorded version and the slideshow. And we will also have answers to your questions in written form as well. So first of all, don't worry about that. Let's have our first question. Are pharmacies considered a business associate, and do you need an agreement, a business associate agreement with the pharmacy?
Pharmacies, I believe, I'll double check this, I think they're covered entities. And there have been some serious data breaches with pharmacies where they've paid the penalty, so if they had been a business associate, that wouldn't have happened. So pharmacies, one of the problems that they had, I believe it was, well, I'm not going to name the pharmacy for fear of being wrong, but one of the large national pharmacies was penalized and paid a severe fine because they were discarding medicine bottles with the patient's names on them. So you'd come in to the pharmacy and say, please refill this prescription, and they would take the old pill bottle and throw it in the wastebasket. That would end up in a dumpster. The garbage truck would show up, and if you've ever seen a truck loading or emptying a dumpster, sometimes papers and other things will fall out of it, particularly on a windy day. So there were pill bottles all over the parking lots of this pharmacy all across the nation. So they are covered, and they can pay the penalties directly. And now let's go back to the new rule. Any organizations that they work with that have access to patient data would be business associates.
Here's another question for you, Mike. I'm a consultant who works on different healthcare program installations. I have responsibilities for management and oversight of projects that deal with patient or claim date, i.e. data conversion, but I do not have direct access to the PHI. Am I considered a business associate?
I'd really have to know a little bit more about what types of services were being offered. I was talking to a consulting company last week, and what they do is they take bills from covered entities that are going to be sent to an insurance company, and they review the bills and point out things that have been missed, particularly billing codes that should be added so that the covered entity gets the maximum reimbursement from the insurance company, and they're touching patient data. So the question that I would have would be more specific. We really can't get into it here, but the part of the answer to the question, I think, is the way that Health and Human Services and the Office for Civil Rights answered a question about the electronic health records companies and are they business associates. And their answer was that they're not business associates because they have published electronic health records software, but they are business associates because they support it. And this is a discussion I've had with a lot of IT companies, particularly online backup companies and cloud providers, who claim that the information that's stored in their systems are encrypted, they don't have access to it, and that's true when it's in a normal situation, when it's on its way in and being stored. But when I ask the question, if they have a problem and you have to support them, don't you get access to the encryption key so you can help recover patient data and prove that it's online so that they can continue working after a disaster, after they've lost a file and had to restore it, or if there's been a big disaster and they have to run their operation from the cloud. And at that point they realize that they are business associates. So part of this question may be that through an implementation project, when you're managing it, you may not have access to specific patient data, but is there any time during the relationship when you do? The responsibility is on the covered entity to work with the business associate and understand what the business associate's doing and explain and make sure that they understand they are or are not the business associate. Really the best answer is for this person to talk with their clients who are covered entities to ask them what they feel, or have the covered entities attorneys or compliance specialists look at the projects and determine whether or not they're a business associate.
There's obviously a lot of questions about the cloud. I'm going to give you two different versions of it, and then we'll move on to something else. But there's a lot of confusion about this. So one question concerns whether ISPs would be considered covered by HIPAA if they're just providing internet service. And my understanding is that they would not be considered a business associate. And then before we get into that, there's another example that's somewhat similar. And this one is if you use a cloud-based accounting system which uploads your bank checking info, and you write checks to patients as refund which include their names and addresses, do you need to inform the patients that you may place their info into a cloud accounting? And do you need to have a business associate agreement with that accounting program? So maybe you could address those two examples of cloud-based services to give us a better sense of where is the line on business associates.
Okay. So going back to the definition of business associates, the Health and Human Services, U.S. Department of Health and Human Services, has said that a business associate is any organization that has contact with data or maintains the data. They've exempted organizations that are what they call conduits. So the simplest one to think about is the U.S. Postal Service, because the U.S. Postal Service delivers to any of us that have health insurance these explanation of benefit forms. After we've been to the doctor or the hospital, we've paid a copay, and our insurance companies may have paid a portion, and we get this notice, this EOB, that lists what a lot of protected information. So the Postal Service is delivering those things to us, but they're not a business associate. And the reason for it is that it's very unlikely, the odds are in the millions, that one of those envelopes may get opened through the postal system, may get crunched in a machine, or someone might accidentally open it. But the Postal Service itself is not a business associate because they're simply moving the data. You have the same exemption for FedEx and UPS, and even though you don't get your explanation of benefits forms, a lot of times the medical labs are using FedEx and UPS. So they're going to send you, for instance, a container, and you're going to do whatever and then send the container back for a lab test. And the organizations that are transporting those containers, even though inside the package it may have your name and some specific information about a diagnosis or treatment, the organization that's moving that package around is a conduit. When we look at electronic data, we have the same type of exemption. So if it's an internet service provider, and I'm going to restrict this only to internet service providers that only offer transport services, because some of the internet service providers have expanded their offerings, and they're offering data storage and some cloud services, and they're trying to get as much business as they can. But if they're simply transporting the data, then they are exempt as conduits. So ISPs and the package carriers and the postal services are not business associates because they're transporting data, and it could be in paper or electronic format. Same thing with the phone company, that when you pick up the phone and you call a doctor's office, whoever is transporting the voice message across the system is not a business associate because they're just transporting the data. Now, the other question about the accounting system being up in the cloud, the only thing I would do is go back to the definition of protected health information, and as long as there's nothing that combines the diagnosis or treatment information with the person's name that's on the check, that information isn't protected. If you write a check to a patient, you can do that as long as you don't add, this is a refund for your, and then put some specific procedure on there, or this is a refund for the visit when you came in for this type of treatment or this type of illness. So the more specific you make the information that's stored up in that system, then you may cross the line to the point where the cloud service is maintaining protected information. But if you don't do that, if it's simply you're making out a check to Brian Johnson for $100, then there's nothing there that's protected. There's no way that anybody would gain any knowledge about Brian's health care by seeing that. But if you say that you're writing the check for $100 and that's a refund for a particular type of surgery or procedure or medication, you've crossed the line and that information is protected.
Thank you, Mike. Here's a question that it comes up quite a bit, and I like this question. What about janitors? So maybe you could tell us a little bit about incidental contact and what are the rules for people like custodial staff?
There's an exemption in HIPAA for incidental contact, and I'll tell you, it's a bit dangerous the more you want to rely on that. So a janitor sweeping an office at night, for instance, may move some papers that on somebody's desk, and those papers are contain protected health information, and they may see the records, and that's considered incidental, in that you don't necessarily need to have a business associate agreement with the janitor's service that employs that person, because they're not accessing the data as part of their work, or the information as part of their work. You need to be careful of this, though, and some organizations have clean desk policies that say that no one can leave their workspace with any protected information on it. You also have to make sure that your systems are secure and not specific to janitors or janitorial staff, but there's not a requirement in HIPAA for encryption of data, but there's an exemption for it. So if a device is stolen and that device has protected health information on it, and the information is not encrypted, that's a reportable data breach. And if it has more than 500 records, it's going to be publicized on a federal website, and there can be pretty severe penalties and costs associated with that.
Maybe you could give us an example of the loss of an unencrypted laptop and how that worked out.
Well, it didn't work out well for a hospital in Massachusetts because a laptop was stolen from a doctor while he was traveling, and that hospital paid a $1.5 million fine for losing the laptop. So let's go back to the janitor for just a second. The more people that have access to devices that may contain data creates a big risk for you for what could be a large and expensive data breach. So the federal government is taking all these things seriously. It wouldn't hurt you at all to take the position, maybe a more conservative position, that anyone that might come in contact with patient data would be a business associate, and you have to work with them because you're going to make them incur some costs and responsibilities, but it's a question of how much risk you want to manage.
Do business associate agreements need to be notarized?
No.
All right. And here's another one about who's a business associate and who isn't. Someone's asking about whether an EHR company is a business associate. And my understanding is that they would be. Is that correct?
Yes, I'd already mentioned that there's a question that's been out for a while now on the frequently asked questions section of the HIPAA area on the Internet for the U.S. Department of Health and Human Services that asks if an EHR company is a business associate or isn't. And their answer, which I've already mentioned, said that because they're publishing an EHR, an electronic health record system, is not the reason they're a business associate, but because they're going to see patient data whenever they install or support it, then they are a business associate. So the answer is yes.
Here's a question about providers. So providers don't have protection under HIPAA per se. The question is, our company obtains and stores provider information only. So is that then under HIPAA protection? In the sense of, I think they mean clinicians, medical professionals, but not the patients themselves.
So can you restate that in terms of, is there a question, is protected health information on patients involved in that question?
The question doesn't specify, but let's assume that there isn't PHI involved.
Well, HIPAA only relates to PHI.
So information on clinicians is not a HIPAA concern necessarily.
No, as long as it doesn't contain any identifiable patient information, again, somebody's name and treatment or diagnosis information.
Here's a great question. Is a business associate responsible for assuring that a covered entity that they work with is HIPAA compliant?
Well, that question comes up a lot, and there is a requirement that says that if you, as a business associate, are aware that a covered entity is not compliant, you are supposed to alert them and terminate your relationship if they don't maintain compliance. And there's an insinuation that you should report them, but I've never seen that happen. It's not really a good way to have business relationships with your clients. But it is something that creates a risk for the business associate that if their client is not going to do anything to comply, then there may be a data breach that they're dragged into, and they may be complicit as far as the Office for Civil Rights goes by knowing that the noncompliance was taking place. For instance, I get questions a lot of the times about our system set up to lock after a certain period of time so that if someone walks up to them, they can't gain access to patient information if the authorized user has walked away. So I get this question from a lot of IT providers, and they really need to be educating their clients about compliance because it's possible that everybody's going to get dragged into an investigation that could become very expensive.
We've got really great questions today. Here's another one. If you have a file clerk and the job of the file clerk is just to file documentation and patient records, is it okay for that file clerk to read the documentation prior to filing it? And the questioner says, the general manager says, in her organization says that it's fine, but she believes that it may be a problem. What advice did you give on that question?
Well, that could be a very long discussion, which we won't have today, but HIPAA has what they call minimal necessary requirements in terms of sharing patient information. It is possible that within a healthcare organization that two employees of that organization talking to each other about a patient could be a data breach. And the reason for it is that HIPAA says that the only people that should have access to the patient information are those that are specifically involved with the treatment or, for instance, the payments related to that patient. So there's a widely known penalty in Los Angeles at a hospital where Britney Spears went in as a patient, and 13 people were fired for snooping in her record. So they had access to the system because they were caregivers, but they were not Britney Spears caregivers. And the system tracked who had access or who had accessed the files. 13 employees were fired and 6 physicians were suspended. So my answer to that question about the file clerk specifically is that if the file clerk has to open up the record to look at something inside of it to determine how to file it properly, then it would be appropriate for that person to do it. If all the information, for instance, is on the label on the outside of the file, and that person opens the folder to read someone's lab information or read their medical record, that is a data breach, even though that employee may have access to a certain level. So within an electronic health record system, there are different levels of access to different things that people can do. And in some organizations, receptionists do not have access to lab reports and test results because their job is so specific that they don't need that. In smaller organizations, a lot of times a receptionist is told to make sure that the labs came back or the test results came back before a patient is scheduled. So it varies based on the role, but you really have to look at what your workforce does, look at each role, and in the case of that file clerk, if it's simply snooping to open the record and read what's in there and not necessary for filing, then that's a data breach.
Well, I'm afraid we're running out of time, but I want to stress to all of our attendees that we will send out written answers to the remaining questions. There's quite a few questions that we didn't get to, unfortunately, but we will follow up and provide written answers to those questions. And those will be delivered via email link later in the week. There's a number of questions about HIPAA training and business associate agreement templates. So I want to, here on the last slide, let me move this. We do offer HIPAA training through Format Approved, and this is vetted content through Mike Semmel. And that training includes a template of a business associate agreement that's available for download. So people who have additional questions about that should contact us. I want to thank Mike for joining us for today's Learning Lunch. I know I learned a lot about business associates and HIPAA requirements, and I'm sure our attendees did as well. I'd also like to thank all of our attendees today. Again, all registered attendees will receive an email with links to both the recorded and PDF versions of this session, so look for those emails. Remember to visit formatapprove/HIT security to read Mike's security column. Visit formattraining.com to register for our Certified HIPAA Security course, which is designed to meet the HIPAA training needs of business associates, designated security officers, and medical staff managers. And again, that includes a template of a business associate agreement. In addition, we offer HIPAA workforce training for medical professionals, including value bundles that enable any healthcare organization to meet its HIPAA training needs, from small practices to the largest hospitals. So visit us at formattraining.com. Finally, be sure to join us at formatapproved.com for our next Learning Lunch session. We will be increasing our dates and topics in the coming weeks. Keep an eye on your email box and our homepage for upcoming topics. And thank you again for joining us today. And Mike, thank you again for sharing your expertise with us today.
Thank you, Brian.